Hello, Elpis partners, and my name is Akram Fazier. I'm a professor of law at the Lincoln Memorial University in Knoxville, Tennessee, and I just want to thank you for inviting me to make this presentation and send my greetings to all of you in Western Europe as well as the United States. I'd like to thank us, of course, Vasco for inviting me to make this presentation as well, and I'm truly honored to do so. So today's the subject of today's presentation is going to be updating the American Administrative Procedure Act in view of as we enter the second quarter of the 21st century. Okay, and so that's going to be our presentation today. And so what am I getting at here? Okay, so here is my PowerPoint slide. Updating the American Administrative Procedure Act to address the rule of law retrogression in the second quarter of the 21st century. Okay, so the focus of this presentation, right? Administrative law in the US has been altogether stagnant since the Administrative Procedure Act was enacted in 1946 at the tail end of the New Deal. Although the APA was enacted based on unanimous voice votes by both houses of Congress, its enactment was part of a nearly 13-year fight between conservatives and liberals that commenced with the New Deal. Okay? It is, according to Professor George Shepard, a mistake to see the APA as anything other than a fierce compromise that was brought about by conservative groups, including the American Bar Association, or ABA, needing a deal that would tether the Truman administration to rule of law norms in the administrative state. Okay? These rule of law norms in the American administrative state are no longer being adequately protected by the APA and need an update. Okay? So what's the risk going forward, right? The risk going forward is presidentialism as practiced today contravenes rule of law principles and risks taking the US down an authoritarian path that infantilizes the remaining two federal government branches and over time delegitimizing and debilitating the American government. A debilitated government risks becoming an economic stratifier that is hostage to the interests of the very rich. It also makes the US over time an inadequate ally and unstable geopolitical partner in international relations. I think that's the key component for all of you in Western Europe. We have already started seeing the Trump administration being a very, very unstable ally to the great democracies of Western Europe. I think if we continue seeing this authoritarian trend, the problem will only get worse. So my proposal is for a broad bipartisan civil society endeavor to fill the gaps in the APA to deal with the growing problem of presidential administration, under this presidential administration, US presidents increasingly set policy for the country without congressional legislation and without congressional oversight. Now, I have to remind you, this could be a very long and arduous process that must be undertaken to prevent the US from turning into what my fear is for the future, an elective dictatorship with a highly restricted franchise, right? Now, my proposal, of course, should not be just limited. My expertise is in American law, but my proposal, I think, applies to the broader Western world in the sense that I think we're seeing this rule of law retrogression apply throughout most mature democracies, okay? So as we see the second quarter of the 21st century, right? Western Europe, Canada, Australia, New Zealand, Japan, and the US have, right, by far superior living standards compared to 90% of the world's population. And this is, of course, leading to a dramatic increase in global migration from the developing world to the developed world, right? Economic power is shifting from the US and Western Europe towards China, India, and South Korea and Southeast Asia. However, the living standard gap remains very large. American economic power remains, but American economic power is no longer used to benefit its reliable allies, such as the countries of Western Europe. While the United States remains a steadfast ally to Israel and the oil-rich states of the Persian Gulf, This is largely due to American domestic politics in the case of Israel and the power of the military and oil lobbies with respect to Saudi Arabia and the Gulf states, okay? So there is a democratic erosion in the US and Western Europe, right? Examples being Donald Trump's willingness to invalidate the 2020 presidential election and his re-election, notwithstanding doing so in 2024, right? Emmanuel Macron's authoritarian attempts to enact legislation without parliamentary approval, his ill-advised decision to call snap elections, and the relative collapse of establishment political parties throughout Europe, right? Now, it must be conceded the West's major economic and geopolitical challenger, China, is avowedly undemocratic and has increasingly become dictatorial. And its secondary geopolitical challenger, Russia, has also become more democratic and murderous than even the Soviet Union was. The largest democracy in the world, India, remains a democracy, but it is also suffering the problem of democratic retrogression, right? As the BJP under Narendra Modi remains very corrupt and is increasingly and remains very hostile to the presence of Indian Muslims and Christians within India. Now, we have to be mindful, right, that although the Western European countries and the United States, right, are places of very high living standards, right, the last major constitutional compacts in major Western democracies took place in the 70s, 80s, and 90s with the democratization of Portugal, Spain, Greece, and then in the 90s with the former Warsaw Pact countries, the most important being Poland, right? France saw its most recent constitutional moment in 1958 with de Gaulle's Fifth Republic, and it's, I think at the time, kind of stopgap constitution drafted by de Gaulle's first prime minister, Michel Debré. Germany's constitutional moment was the creation of the Federal Republic of Germany in 1949, and that has endured since the time of Adenauer. Italy's system has endured since 1946, when a referendum ended the monarchy and established a parliamentary republic in 1948 under de Gasperi, right? The United States is a little different, right? It has had a continuous constitutional system since 1788, although the US can be fairly divided into several republics. Now, this is my thesis. It's not necessarily universally accepted, but bear with me, right? I would say the first republic was the Articles of Confederation that commenced in 1776 and ended with the ratification of the Constitution in 1788. This was a very, very loose confederation that saw the United States landmass dramatically increase with the acquisition of what was called the Ohio Territory, but it was seen as not working because the federal government was seen as too weak compared to the states. Then we have the Second Republic, which endured from 1788 until 1861, when the Madisonian Constitutional Compromise collapsed, right, by secessionism due to slavery. Okay, so that ended in 1861 with the election of President Lincoln. The Third U.S. Republic was created after Lincoln and the U.S. Army's victory over the Confederate States and the imposition of Reconstruction in the American South. The Fourth Republic endured from Reconstruction until 1933. Okay. And when an economically vibrant but grossly unequal system of country collapsed due to the Great Depression and the constitutional moment that was the New Deal under Franklin Roosevelt. I would say the Fifth U.S. Republic endured from the time of the New Deal until 1965, when the Civil Rights Acts of 1964 and the Voting Rights Acts of 1965 finally changed a racially hierarchical democracy and superpower into a multiracial one, okay? And the Sixth Republic, which we live in today, I would say, is perhaps a concomitant and a backlash against the arrival of a multiracial democracy, which has seen, of course, a dramatic increase in migration from largely Latin America to the United States, okay? It is characterized by economic and military dynamism, but has tremendous economic and racial inequality, political hyperpolarization, congressional immobility, and an unstable governing framework based on hyper-contestation for the White House. In other words, in the United States today, increasingly the only election that matters to Americans and the political culture is who wins the White House, which is a greatly different situation than in the past. Also, compared to the past, we don't have political candidates for the White House who have overwhelming national appeal. The margins are very tight, and this leads to, for example, the temptation towards voter suppression. One factor that explains this instability, as I said earlier, is the growth in the number of unauthorized migrants, which now stands at approximately 13.7 million persons as of November, right? As of November 2025. Okay. Now, the United States, in its sixth republic, that's at this present moment, is a country of 342 million inhabitants, making it by far the most populous rich country in the world, right? That comes from the US Census Bureau. It is about 72% white, 14% Hispanic, 13% Black, 5% Asian, and a non-insignificant number of Native Americans. Its GDP of $30 trillion, an unemployment rate of only 4.3%, though, make it one of the richest countries in the world and by far the richest large country in the world. It also has by far the largest military budget of any country in the world, as it spends more on its military, roughly $1 trillion, than the rest of the world combined. And so this is a country with many strengths, right? It has the most powerful military and economy in the world. The US dollar is the world's reserve currency, which enables the United States to borrow profligately. Right now, for example, the United States is a country with a $30 million economy, but has a $38 trillion debt. And this is facilitated by the fact that English has become by far the dominant global language, and the United States is the destination point for many of the world's high-skilled workers and foreign students. It also is the home to the world's most valuable companies, especially in big tech. You all know this, and is home to the world's most prestigious universities, right? But the US has many weaknesses. I just said, for example, the United States is home to the world's most prestigious universities, but it does have also within its portfolio of universities amongst the world's weaker universities for a rich country. The quality of the democracy is weakening, and government shutdowns typically happen every presidential term. The US is increasingly seen by its allies as a bullying superpower as opposed to a benevolent hegemon, protecting the international system. I think we all know the examples, right? It's threatened Canada with, it's threatened Denmark with trying to take Greenland. It is imposing tariffs unilaterally, and its commitment to NATO and the defense of Ukraine has been, to put it mildly, wavering. The Trump administration is increasingly hostile to the rule of law, civil liberties, non-citizens, and racial minorities. The US also has very high levels of income and wealth inequality that is more akin to a developing country like Brazil or China than to a mature country like we see in Western Europe. Okay. So one thing that explains this is living standard stagnation, right? Especially amongst the white middle class, has fed support for racial populism that is hostile to migrants, fed support for illiberal politicians such as Trump, and has overall undermined support for the rule of law. Now, these are weaknesses shared with European countries, right? Let's be candid. While both Western Europe and the US have exceedingly high per capita incomes, they both have seen living standard stagnation as compared to the period from the 1940s to the 1980s. Both Western Europe and the US are struggling with accommodating a growing population of migrants and immigrants. This is especially so in economically distressed regions, which has fed the growing popularity of far-right politicians in both regions, right? We see Nigel Farage in the UK, Marine Le Pen in France could be the next president of France. We see that the AfD is growing in popularity in the Federal Republic, right? And of course, we see Trump here in the United States. In both Western Europe and the US, the growing migrant population is also blamed for the increasing housing unaffordability problem, especially in economically vibrant cities, okay? So the rule of law and democratic retrogression. The problem of executive branch overreach, okay, that has corresponded with rule of law and democratic retrogression is manifest in all mature democracies. Examples include France's Fifth Republic is teetering and at this point is on the verge of seeing Marine Le Pen enter the Elysee Palace. And most likely once she does so, she will most likely sideline or suspend the National Assembly and illegally and forcibly repatriate all migrants from France back to, for example, Algeria and other places in Africa and the Middle East. Germany, under the chancellorship of Friedrich Merz, is also teetering, and Germany might well be forced to include the AfD in any future government. The UK is likely to see the collapse of both the Labour Party and the Conservative parties in the next election and may well see Nigel Farage enter Downing Street. And we see these problems, of course, of democratic retrogression and the growth of far-right movements in Portugal and Spain. And we see, for example, effectively, a far-right leader is in power in Italy already, though she has, of course, been relatively effective at governing Italy. That's Giorgia Meloni, right? The US under Trump is already eroding and likely to face a constitutional crisis in 2028 if Trump refuses to abide by the US Constitution's 22nd Amendment that disallows his re-election as president. I think the counterfactual we have to more likely contemplate is even if he officially leaves the White House, right? Trump may well attempt to hold on to de facto power behind the scenes, which is what Vladimir Putin did when he officially transferred the presidency over to Dmitry Medvedev in 2008. So the likely mistake for all of us is a failure to recognize the relative collapse of organized labor in mature democracies, and the growth of a migrant population has shifted the native-born working class, right, towards far-right parties. It's a likely mistake to see this authoritarian backsliding as ephemeral and not to address defects of administrative rule of law in the hopes that the problem will disappear over time. I think the obvious example we can think of off the top of our minds is, I think many progressives in America thought the problem of the far right or the Trump phenomenon was dealt with in 2020 when President Biden defeated him in the 2020 election. So the growing problem of presidential maladministration, okay? Hold on. So increasing presidentialism in American administration that relies on presidential fiat is a growing problem, okay? So a growing problem of presidential maladministration affects the US. Increasing presidentialism in American administration that relies on presidential fiat, as opposed to the reasoned elaboration of government policy by administrative agencies, has become paradigmatic, right? So examples include using an executive order as opposed to a law to create an agency, which is what, right, which is illegal, under Elon Musk called the Department of Government Agencies to gutter agencies of their personnel, in other words, fire people when they shouldn't be let go, and close down agencies such as USAID, the United States Agency for International Development, without Congress's approval. Two is using an executive order to have U.S. Citizenship and Immigration Services deport large numbers of migrants without affording them hearings before immigration judges. The problem being so bad is USCIS was not doing proper work, denying them hearings such that people who were legal migrants were being deported. They also started firing immigration judges who were perceived to be sympathetic to migrants, right? So these are three problems. But the problem goes on. The administration started firing members of independent regulatory commissions, such as the Federal Trade Commission, before the expiration of their term in office, and it threatened to fire the Federal Reserve Chairman on many occasions. This, I think, has caused some concern on the international markets, and I think it will lead people over time to lose confidence in the dollar. The administration has also started using administrative guidance memos and policy statements that are unreviewable in court because they're non-final agency actions, right, to achieve illegal goals, right? They illegally force the end of diversity and inclusion programs at universities and at private sector employers. And they have forced universities to clamp down on First Amendment speech on dubious claims, based on dubious claims of anti-Semitism, right? These are just 5 examples I can think of right now. There are many more. The focus of this presentation, though, is to take steps to convene civil society to arrive at a consensus of updating the Administrative Procedure Act to adapt it to the growing problem of presidential administration, right, that is debilitating the government and eroding our democracy. And an analog to this is needed, I believe, in Western Europe to address the twin problems of living standard stagnation and migration influx from the developing world. Now, ideological approaches to administrative law then and now. If we go back in time, at the time of the New Deal, initially it was conservatives who objected to the New Deal and presidential administration to the degree there was any. And it was conservatives who argued for a greater role for reviewing courts and the public in administrative law. This was at the time objected to by liberals who argued it would debilitate agencies and prevent them from addressing public needs. Today, it is liberals and the liberal and conservative positions have switched, and it is liberals who argue for hard-look judicial review of agency actions and notice and comment rulemaking that it should not be bypassed. Conservatives, by contrast, argue for broad White House discretion under what is called the unitary executive theory. So my argument is that civil society, from all ranges of the political spectrum, needs to be convened to address gaps in the APA that do not account for the problem of presidential administration. Now, a potential solution, right, is, first of all, to convene civil society with the goal of finding some sort of compromise to address changes in American government and society since the end of the Cold War. I think some means that this civil society group should arrive at some means whereby presidential administration of agencies is subjected to some review, okay? One thing could be to streamline the administrative rulemaking process so that presidential administrations no longer feel compelled to bypass rulemaking as a means of updating legislation. I think over time, since the New Deal was enacted, since the APA was enacted, rulemaking has been the paradigmatic means of administrative enforcement. But because the courts have added so many requirements into rulemaking, it has become altogether sclerotic and ossified and takes too long to be effectuated. And as a result, presidential administrations tend to bypass it. Another thing is to require federal agencies to develop and complete and publicly accessible rulemaking record. Another thing I would recommend is to legislatively update the Administrative Procedure Act to mandate review in courts, defer to agency rules based on permissible interpretations of law, but only in situations where the interpretation is arrived at after notice and comment rulemaking. In other words, I'm calling for a resuscitation of Chevron deference, which is a better form of policymaking than anything else. I also recommend creating a Federal Office of Administrative Procedure, right, whose head is to be nominated by the president and confirmed by the Senate, and whose job will be to coordinate administrative rules and procedures throughout the administration and be fully accountable to both the White House and Congress. This Federal Office of Administrative Procedure will replace the Office of Information and Regulatory Affairs, known as OIRA, that is now considered part of the White House and is not subject to congressional oversight. The FOAP must publish a uniform regulatory agenda online that explains how all rules are to be resolved, list all active rulemakings, and make a reasonable effort to clarify all agenda items. It is to disclose all White House involvement in the rulemaking process by having each agency disclose the substance of executive supervision, with the goal of making the sitting president directly accountable for how the rulemaking unfolds. Because the rulemaking will be streamlined, ideally the temptation to presidentialism will be reduced. I think another thing that the APA should address in an amendment would be a clarification of the judicial review of court decisions, such that administrative actions, decisions, and rules are to be reviewed under a deferential standard and not the recently developed major questions approach to judicial review that allows review in courts to effectively second-guess policy choices. And then finally, have courts allow discovery. In other words, in litigation in America, you have a requirement that each side have access to the other side's documentation, and have discovery be a means of a transparency forcing to uncover political influences that agencies perhaps might have failed to disclose to the Federal Office of Administrative Procedure. But I mean, the thing I want to emphasize is any new administrative compromise could take a great deal of time and needs an overwhelming consensus brought about by, for example, empathy and, last but not least, exhaustion. And that's what happened to arrive at the initial compromise that was the APA. Right? So let's get back to the background history towards the APA. And I think the initial moment was 1929, right, which started with the Depression, that it commenced with the October crash of the American stock market. But I think Americans get it wrong. A recent book by Andrew Ross Sorkin has evidence to me that the most significant moment in the Great Depression was not the October crash, but it was actually the passage of the Smoot-Hawley Tariff in 1930 that led to a global economic downturn and a collapse in U.S. gross domestic product of approximately 30%. So in 1929, a liberal U.S. senator named George Norris proposed a bill to create an administrative court of justice that would hear all appeals of and challenges to agency conduct. Congress took no action and the bill failed. We then see in 1933, right, the arrival of Franklin Delano Roosevelt as president, okay? And he brought in the New Deal, and he sought to use the power of the federal government through its agencies to resurrect economic demand and lift the country out of the Depression. there was a conservative reaction to this. An early conservative reaction was conservative Democratic Senator Mills Logan of Kentucky proposed reintroduction of the Norris Bill, but this failed due to FDR's immense popularity at the time. And the Roosevelt administration had Congress create several New Deal agencies. And these included, for example, the Civilian Conservation Corps, which hired unemployed young men for environmental projects, the Public Works Administration, which employed people to build public buildings, roads, and bridges, the Works Progress Administration, which hired millions of unemployed people for public works projects, the Tennessee Valley Authority, which is headquartered right here in my home city of Knoxville, which provided rural electrification and flood control to a 7-state region, the Federal Deposit Insurance Corporation, which insured bank deposits to restore confidence in banks, the Homeowners Loan Corporation, which refinanced mortgage loans to prevent foreclosures, the Federal Housing Administration, which used mortgage insurance to stabilize the mortgage market, the Agricultural Adjustment Act, which paid farmers to reduce crop production, the National Recovery Administration, which established codes of fair competition, including setting minimum wages, and the Social Security Administration, which created a system of retirement benefits and unemployment insurance. These New Deal agencies had New Deal agency powers, and these powers included legislative power to promulgate rules that have the force of law based on congressional delegations of legislative power. They had the executive power to bring enforcement actions against those who violate federal laws and regulations by way of adjudications, and judicial power to hear and adjudicate cases brought by agency officials against those accused of violating federal law or agency regulations. So the Special Committee on Administrative Law was set up in opposition to the New Deal in 1933. It manifested effectively corporate law opposition to the New Deal, and corporate law was opposed to the New Deal largely because big law's corporate clients were opposed to the New Deal, okay? The committee opposed the combination of legislative, executive, and judicial functions within agencies on the ground that this usurped the proper role for courts in the American system. It proposed, on separation of powers grounds, the creation of a specialized administrative court that would assume all agencies' adjudicatory functions, right? Now, initially, the APA the American Bar Association took a back seat because the Supreme Court was the chief opponent that Roosevelt confronted in the early New Deal, right? So the Supreme Court in the early 1930s, was dominated by Republican appointees, right, whose appointments dated back before the 17th Amendment, right, when senators were appointed by legislatures not directly elected. And as a result, these justices tended to be very unsympathetic to public opinion. In fact, they saw public opinion as corrupting. And this early New Deal Supreme Court rejected much of FDR's New Deal legislation. For example, on May 27, 1935, on Black Monday, the Supreme Court issued 3 decisions that narrowed the power of New Deal agencies that were seen as a threat to the American free enterprise system. Okay? And this led FDR to, I think, commence an ill-advised court packing plan. FDR threatened to pack the court with New Deal-friendly judges, and then, when afforded the opportunity, reconstituted the court with New Deal supporters, including Justices Black, O'Douglas, Frankfurter, Stanley Reed, Frank Murphy, James Burns, Harlan Stone, Wiley Rutledge, and of course, Robert H. Jackson. Now, the threat to pack the court led the Supreme Court eventually to back down to FDR, but it cost him immense political popularity, right? And the American Bar Association was especially opposed to the court packing plan, seeing it as an anti-democratic maneuver, right? And the ABA therefore sought to have some form of statute rating in agencies be created, right? That would put them on a shorter leash. So the ABA's 1935 report suggested mild reforms to adjudications, right? And its 1936 Logan report led to the Logan-Seller Bill, named after Senator Mills Logan and Representative Emanuel Seller, right? It sought to expand upon previous proposals and create a new U.S. administrative court that would replace internal agency adjudicatory bodies with an even more centralized administrative court that added the jurisdiction of the U.S. Customs Court and the U.S. Board of Tax Appeals. It died, though, in committee largely because FDR opposed it, and FDR was still very popular. According to George Shepard, the Logan-Seller bill's failure demonstrated to the ABA and FDR's conservative opponents that only a bill that appealed to the president would succeed. So how did we get there? Well, one factor facilitating the eventual APA was the fact that Roosevelt and the presidency lost power tremendously after the failure of the court packing plan and the recession of 1937-38, right? So the court packing plan failed, and then the 1937-38 recession saw US GDP collapse by approximately 11%. Much of that was due to the fact that the private sector became very skittish about the New Deal, and that destabilized the economy. The ABA committee, headed by Colonel O.O. Maguire, proposed a bill that anticipated the APA and would reform agency procedure and provide additional judicial review of agency decisions. It also proposed to place constraints on agency rulemaking by notice, a hearing, publication in the Federal Register, and the opportunity for immediate judicial review. According to Shepard, a coalition against the New Deal emerged that was an unstable one, but a real one. It consisted of Republicans and anti-New Deal Democrats, right? That could often coalesce to block FDR's initiatives. This coalition was aided by business interests and, of course, their lawyers at the ABA. And it really, really materialized in 1938 with the enactment of what was called the Walter Logan Bill. So in the late 1930s, demand for administrative reform peaked, in large part due to concern that European-style fascism and communism would, without administrative reform, infect U.S. government. Conservatives would pass and nearly overrode FDR's veto of the ABA-supported Walter Logan Bill, which was a highly restrictive administrative reform bill that would have expanded judicial review of agency actions. This veto narrowly failed, largely because FDR retained popularity with the broader public and the country was on the path to World War II. Okay? So Roosevelt convened at around the time of his veto of the Walter Logan Bill, the Attorney General's Committee to Study Administrative Reform. So Roosevelt thinks, right, he could basically defang the Walter Logan Bill by having the Attorney General's Committee be convened to provide something milder. So on February 16, 1939, only a month after the Walter Logan Bill's Senate introduction, FDR asked his then Attorney General, Frank Murphy, to form a committee to study administrative reform and propose legislation. The Attorney General's Committee included 12 distinguished practitioners, judges, and professors. 8 were New Dealers and 4 were conservatives, right? The Attorney General's Committee included Professor Walter Gellhorn of Columbia University and Kenneth Culp Davis, who both were ABA opponents and both sought to reform the system for purposes of efficiency. According to George Shepard, though, these 2 individuals, brilliant as they were, often overlooked the fact that the battle was a purely political one over the New Deal's very survival. Okay? The AG committee's report finally came out 2 years later, 4 weeks after the House failed to override FDR's veto of the Walter Logan bill. The committee failed to agree on a single recommended bill and instead submitted two. One agreed to by a majority of its members, and the other one by its conservative members, the minority bill, as it's called. The majority report, which was introduced in the Senate as Senate Bill 675, it rejected the minority's recommendation of notice and comment. So the majority report rejected the request for notice and comment of the rulemaking procedures on the grounds that it would cause needless delay and make rulemaking too expensive. The Attorney General's Committee's primary proposal was for the establishment of a Federal Office of Administrative Procedure that was given two primary functions. First, it would investigate and confirm the new class of hearing commissioners that each agency would nominate. And second, it would investigate and make reports about complaints that the FOAP received about agencies and examine agency procedure for improvement purposes. Instead of the conservative recommendation that agencies adopt notice and comment, the bill merely required each agency to designate at least one committee, board, officer, or employee to receive suggestions and expedite the making, amendment, or revision of rules subject to the control and supervision of the agency. The minority report, by contrast, recommended a notice and comment in the rulemaking process, right? It also presented an extensive, detailed code of standards of fair administrative procedure that would have controlled agencies substantially, right? The FOAP proposal of the majority report was supplemented by a new requirement of notice and comment, as I just said, and these comments and notices must be published in the Federal Register. It also provided for stricter procedural requirements in adjudication, including greater separation of prosecutorial and judicial functions, and provided for judicial review under a stringent substantial evidence standard, which would be more strict than the standard at the time, which was called the scintilla rule. Then also a third bill was introduced by Representatives Hatch and Van Nuys, right? Which combined the most restrictive section of the Walter Logan bill and the AG committee's minority bill. Representative Walter introduced the same bill in the House. Senate Bill 918 restricted agencies by means of adjudication rules, rulemaking requirements, information requirements, and intrusive judicial review. Okay? Now, the ABA and business compromise proposal, right? At this very same time, the ABA started to become a little more willing to work with FDR, partly because FDR had been around for so long and remained popular. And so the ABA began to seek a compromise and voted to endorse the Senate minority bill as opposed to S918. Business groups, however, preferred Senate Bill 918, but they signaled that they found the minority bill from the Attorney General's Committee acceptable. Now, organized labor, though, they tended to support the majority bill and rejected both Senate Bill 674 and 918. William Green and his CIO, or Congress of Industrial Organizations, had opposed the Walter Logan bill, viewing it as a conservative attack on the NLRB, or National Labor Relations Board. Remember, the National Labor Relations Board is a multi-member commission that was brought in during the New Deal to protect workers' rights to form unions if they so chose. But there was, of course, a long period of inaction during World War II as the country shifted focus to deal with this catastrophic war. Congress enacted no further on the three bills during the war emergency. According to Shepard, this period of inaction created 6 conditions that paved the path to the eventual enactment of the Administrative Procedure Act. The first was, right, public eventually was brought along to the need for administrative reform, And this was largely, according to Shepard, brought about by the fact that the public was getting sick of what they perceived as administrative incompetence and agency abuses, which led to chronic shortages during the war. Agencies were also blamed for surging inflation and rationing. The war weakened congressional Democrats politically as Republican gains in the 1942 midterm elections meant that a coalition of Republicans and Southern Democrats could now defeat the administration and perhaps even override a presidential veto. FDR, who was probably the greatest politician in American history, understood the country's political mood as well as anybody and decided to replace his hard left vice president at the time, a man named Henry Wallace, with the moderate Harry Truman of Missouri to be his running mate in 1944. Roosevelt retreated in domestic battles over the New Deal as well, because he tried to shore his political base. And as a result, Roosevelt appointed many Republicans, such as Henry Stimson, to his cabinet and agreed to the elimination of several New Deal programs, such as the Civilian Conservation Corps, the Works Progress Administration, the National Youth Administration, the National Resources Planning Board, and the Farm Security Administration. At the same time, conservatives became less stringent on administrative reform because Roosevelt had appointed liberal judges from almost a decade at this point, and conservatives felt, greater judicial review is not going to do us much benefit because those judges are now a bunch of liberals appointed by Roosevelt, right? And so they no longer saw courts as the safe haven that they did see in the early 1930s. The ABA also abandoned the combative approach it had taken since the start of the New Deal, recognizing that attacks on the administration were not yielding results in terms of policy progress. This explains why the ABA purged Colonel O.O. Maguire's committee of 4 or 5 members, including Maguire himself, as a peace offering to the administration, and they replaced Maguire with the much more administration-friendly Carl McFarland. Conservatives became less insistent on administrative reform because Roosevelt, as I said earlier, had appointed liberal judges. Attorney General Francis Biddle also, who was Roosevelt's Attorney General at the tail end after Murphy went to the Supreme Court, had worked closely with McFarland and took also a greater interest in administrative reform than Roosevelt's previous attorney generals. And this takes us to, for example, Senators Pat McCarran of Nevada and House member Hatton Summers of Texas, both conservative Democrats who enacted the McCarran-Sumner's bill that eventually became the Administrative Procedure Act. That McCarran-Sumner's bill of 1944 was shorter and created clearer requirements, but fewer of them than the minority bill in the Senate from the Attorney General's report. It discarded the minority bill's provisions for the establishment of a Federal Office of Administrative Procedure. That may well have been a huge mistake. Like the minority bill, it created a single detailed code of procedure for all agencies while intruding less on agency autonomy. It had 6 major features, right? It required each agency to publish, not necessarily in the Federal Register, its internal organizations, its rules, regulations, and any interpretation of them that were of general public application, and all formal and informal procedures available to private parties in dealings with the agency. The bill compromised with agencies on rulemaking. Unlike the conservative Walter Logan bill that had required notice and public hearings on all proposed rules, the new McCarran-Sumner's bill distinguished between formal and informal rulemaking and required a public hearing on a rule only if another statute, for example, the statute that created the agency, independently required a hearing on the rule. This was the genesis of notice and comment in formal rulemaking. The new bill dispensed with the Walter Logan bill's requirement that full hearings be provided for all adjudications, and instead required that formal hearings be provided only where the organic statute authorizing the agency did so. Fourth, the new bill established extensive due process protections for parties in formal rulemaking and formal adjudication, including a prohibition on ex parte communications. In other words, talking to the other side or to the hearing officers outside of the proceeding, and the provision of judicial authority and civil service job protections to administrative hearing officers. Like the minority bill, the new bill granted extensive judicial review of both informal and formal rulemaking under the arbitrary or capricious or substantial evidence standard that was deferential but sizably more demanding of agencies than the highly deferential scintilla rule that had required reviewing courts to uphold agencies in situations where there was only a minuscule amount of supporting evidence. The bill protected applicants for licenses against agency delay and arbitrariness by automatically granting license applications in situations where agencies fail to take action within 60 days. So here's President Truman, who takes office in April 1945, very early into Franklin Roosevelt's fourth term, when Roosevelt dies in office. So Truman assumes office. Truman was sympathetic to concerns about agency abuses because that was part of his job as a U.S. Senator from Missouri. He was in charge of looking at of figuring out production problems with war production. Okay. Truman was also weaker politically than FDR, never having been elected himself, and did not have the political capital to spend fighting administrative reform. Truman also was to the right of FDR politically and signaled he would not sign an administrative reform bill without the support of his Attorney General Tom Clark and the agencies. Negotiations took place between committees from both houses, the agencies as represented by the AG, and private civil society organizations such as the ABA. And so the McCarran-Sumner's bill, right? While senators preferred a stronger bill and Attorney General Tom Clark preferred a less robust bill, the groups chose not to revise the McCarran-Sumner's bill because ambiguity, according to Shepard, was essential to reaching agreement, with each side hoping the courts would, in the future, favorably resolve ambiguities in the bill. The Senate passed the bill on an apparently unanimous voice vote, notwithstanding rumblings from conservatives that it was too lax, and from liberals that it was the opposite, right? On May 24th, 1946, the bill passed the House in an unrecorded voice vote, with contemporary accounts indicating the vote was unanimous as well. Like the Senate, most House members would have preferred a stronger bill, but recognized that it had already been endorsed by Attorney General Tom Clark and was to be signed by Truman. George Shepard writes that Republicans proposed no amendments to the bill, not because they adored it, but because they feared upsetting a delicate compromise and understood that a flawed bill was better than nothing. Shepard writes that the APA's unanimous passage does not indicate conservatives and liberals were thrilled with the bill. Rather, they all preferred the bill to the status quo. In short, any reform to no reform at all. And although both FDR and Truman administrations could have insisted on a harder bargain, neither did with the passage of time and the goal of gaining conservative cooperation during World War II and the Cold War. Conservatives agreed to the APA not because they had come to approve of agency power, but because they had no choice, because they knew that Truman would have vetoed anything stronger. Right? So George Shepard writes that the fight over the APA was neither a manifestation of the search for truth and efficiency, nor a theoretically centered debate on the appropriate role for government and governed, but rather a pitched political battle for the New Deal's life. The fact the final bill passed by voice vote was not a manifestation of overwhelming consensus, he writes, right? But it reflected a hard-fought compromise where congressional unanimity reflected the reality that perfection was the enemy of the good. Now, Professor William Eskridge and John Frere-John of Yale Law School, they see the APA, unlike Shepard, as a deep compromise, not a strategic one, right? That was the culmination of a lengthy debate as to the means of reconciling the New Deal's need for dynamic lawmaking with traditionalist insistence on democratic accountability and the rule of law, right? They see the APA as a deep compromise that reflected many factors, including the ABA's change in leadership to include New Deal sympathizers prepared to accept the legitimacy of the administrative state. They write that the APA managed to concurrently advance democratic values with due process by, right, modeling the APA as a version of what they call folk democratic theory, whereby government power, when possible, is exercised directly by the people. Although the agency's reasons are directly given to Congress or the courts, agency accountability, according to Eskridge and Fairjohn, ultimately assured by elections and judicial review, right? Each side altered its goals and realized that broad delegations of legislative rulemaking power to agencies was necessary, and that rulemaking required the input of stakeholders in notice and comment. There's, of course, a problem, though, right? There's a lack of a supervising agency. In other words, the APA dispensed with the administrative, the earlier Attorney General report recommendation that there be there should be a Federal Office of Administrative Procedure created. So the APA failed to incorporate that and empower a single agency to oversee other agencies in the elaboration of rules, principles, and norms over time. This has had a cost, right? Congress has altogether failed to update the ABA, and the task of updating has been accomplished by the federal courts filling in the details common law style. The most significant failure is the Administrative Procedure Act's inability to contemplate divided government and the twin problems of congressional immobility. In other words, Congress doesn't have the political capital to do anything anymore, and presidential administration, whereby the president seems to have taken the policy-making role from Congress and changes policy on his own. So what are some of the judicial common law amendments to administrative law since the APA? The first would be the requirement of a detailed notice of proposed rulemaking in the informal legislative rulemaking process that makes rulemaking exceedingly time-consuming and resource-intensive and therefore expensive, right? That was nowhere required in the APA, but the federal judges have started requiring it over time. Their goal was benevolent, to make rulemaking more accountable, but it has really over time made rulemaking exceedingly resource-intensive and time-consuming. Another is the requirement that agencies engage in hard look review in the rulemaking process that ostensibly disallows political considerations. And the courts have used this over time. One of the early cases that required hard look review was a case called Citizens to Preserve Overton Park, which goes back to the 1970s. That may be done, but it's become very, therefore, difficult for rulemaking to be effectuated, and it's led presidential administrations to bypass rulemaking quite often. Another is the requirement, until it was overturned, that reviewing courts defer to agency rules in situations where they are permissible interpretations of ambiguously worded legislation. This was known as Chevron deference. I believe the case that reversed Chevron eventually in 2024, a case called Loper Bright Enterprises, was a mistake. And then there's the present requirement that agency rulemakings that are of major political and economic significance be based on explicit authorization to do so by Congress. This is known as major questions doctrine, which is, I also think, is mistaken because it posits perhaps too large a role for politically unaccountable and non-expert reviewing courts, and it minimizes the power of agencies. Now, the executive branch also has changed since the APA, and this has been unaddressed as well. And the obvious example is the president's increasing use of proclamations, executive orders, and guidance memos that bypass Congress and the agencies to change policy, right? For example, right, this didn't start with President Trump, but President Obama sought to defer the deportation of illegal immigrants by way of a Department of Homeland Security memorandum that never went through notice and comment. But President Trump has taken this to a new level. And he, on his own, created a Department of Government Efficiency, or DOGE, under Elon Musk's power, right, by executive order, and had DOGE unilaterally, right, defund agencies in contravention of congressional appropriations. It also eliminated agencies such as USAID, and one of the Hornbook understandings of American law is only Congress can eliminate an agency, the president cannot. The president also sought to systematically impound money that Congress has appropriated and defund agencies illegally, and he's used guidance memos to alter the meaning of non-discrimination laws to harm non-white workers, right? So in my world, the president has threatened, for example, universities nationwide with loss of federal funding and access to student loans, for example, if they don't adopt the presidential administration's understanding of what non-discrimination means. And the administrative suppositions, many, of course, that were unaddressed by the APA, right? The first is, what is the legality of multi-member regulatory agencies whose heads are given fixed terms in office and can only be removed for cause, right? The APA did not address this. It was a Hornbook understanding. It was legal, right? And these multi-member agencies include the Federal Reserve, the Federal Trade Commission, the Securities and Exchange Commission, the National Labor Relations Board, the Merit Systems Protection Board, the Federal Energy Regulatory Commission, the Federal Deposit Insurance Corporation, the Federal Communication Commission, the Federal Election Commission, and others, right? Now, in a case going back to 1935, 11 years before the APA's enactment, the Supreme Court concluded in a case called Humphrey's Executor that multi-member commissions are illegal, and it's improper for a president to try to fire a federal trade commissioner before the expiration of his term in office, right? However, when he assumed office in January 2025, President Trump fired 2 Democratic members of the FTC, right? And in September 2025, the Supreme Court issued an unsigned order that allowed Trump to proceed with the firings while the case is proceeding in the lower courts. That case was Trump v. Slaughter. There's also the lack of a supervising agency, right? The APA failed to incorporate the Federal Office of Administrative Procedure and empower a single agency to oversee other agencies in the elaboration of rules, principles, and norms. Congress, also unanticipated by the APA, has been really incompetent in dealing with the problem of divided government, and the task of updating, right, has been systemic rule of law retrogression, with the federal courts filling in the details. So one aspect of it is what's called the unitary executive theory, which is a conservative theory of executive power that dates back to a case called United States v. Myers in 1926, and it has found strong saliency 100 years later with the Roberts Court. It takes the position that the president cannot be subjected to quote-unquote for-cause removal standards, right? Because this inhibits his ability to take care that the laws be faithfully executed. In other words, the argument goes, whenever you say a president cannot fire a member of an agency or head of an agency, that's diminishing the president's power too much. And they take this position even though the law that tethers the president's ability to fire executive officials was previously signed into law by the president. The unitary executive theory calls into question the legality of multi-member regulatory agencies, such as the Federal Reserve. So, for example, the Federal Reserve, is that legal going forward? It was created in 1913, and it is a multi-member board headed by a Fed chair. The individual Fed governors are appointed for 14-year staggered terms, and its chair is appointed for 5-year renewable terms. All board members have for cause removal protection under the Federal Reserve Act that was signed into law by President Wilson. But in spite of this, President Trump has repeatedly mooted firing Fed Chair Jerome Powell and went so far as to attempt to fire Fed Governor Lisa Cook, who successfully sued for reinstatement. The Supreme Court has agreed to hear her case in January 2026. So what would be a potential solution with all these gaps? And my recommendation is we have to bite the bullet in the United States and convene all elements of civil society and have some means of discussing ways of administrative reform to deal with the problem of presidential administration, right? And the issue of multi-member regulatory commissions and their ability to withstand judicial review with the growing saliency of the unitary executive theory. Okay? This may take many years to resolve, but I think it's necessary. We also need, and hopefully this convening of civil society will provide some means of legally reviewing presidential administration of agencies, right? We have to do this bearing in mind that at the time of the APA, people thought presidential administrations favored liberals and progressives, and rule of law norms favored conservatives, but now the opposite is the case. There needs to be a means also of streamlining administrative rulemaking so that presidential administrations no longer feel compelled to bypass rulemakings as a means of updating legislation. Reversing the judicial practice of mandating agencies provide all the information the agencies considered in drafting the proposed rule. Also, maybe require federal agencies to develop and complete a publicly accessible rulemaking record to improve transparency, and maybe reinstitute, number 5, Chevron deference as a means of paying some homage to the fact that agencies are both more accountable and have more expertise than reviewing courts. 6, as I said earlier, maybe go back to the Attorney General's report and create a Federal Office of Administrative Procedure whose head is to be nominated by the president and confirmed by the Senate, and whose job will be to coordinate administrative rules and procedures throughout the administration and be fully accountable to both the White House and Congress. Ideally, it will replace the president-only appointed OIRA director that is part of the White House and not subject to congressional oversight. FOAP must publish a unified regulatory agenda online that explains how all rules are resolved, list all active rulemakings, and make a reasonable effort to classify all agenda items. It should also disclose all White House involvement in the rulemaking process by having each agency disclose the substance of executive supervision with the goal of making the sitting president directly accountable for how the rulemaking unfolds. Because the rulemaking will be streamlined, ideally the temptation to solo presidential action will be reduced. I think we also need clarification on the proper meaning of judicial review of court decision, right? Such that administrative actions, decisions, and rules are to be still deferentially reviewed as opposed to application of major questions doctrine, which posits, I think, too high a role for courts and could overwhelm the court system. And then also finally, have courts allow for transparency forcing tools to uncover the political influences that agencies perhaps fail to disclose initially. So in conclusion, right, the initial conservative objection to the New Deal argued for a greater role for review in courts and the public in administrative law. This was objected to by liberals who argued it would debilitate agencies and prevent them from addressing public needs. Today, the liberal and conservative positions have switched, and it is liberals who argue for hard-look judicial review of agency actions and that notice and comment rulemaking should be paradigmatic as a means of policymaking. Conservatives, by contrast, argue for broad White House discretion under the unitary executive theory. But of course, this could all change, and conservatives, right, would probably not feel comfortable about broad White House discretion if Democrats start winning the presidency more often, right? As a result, I think civil society needs to be convened to address the gaps in the APA to fix the problem of lawless administrative law in the United States as it is unfolding. Because this lawlessness could lead to not just incipient authoritarian, but it could make authoritarianism paradigmatic, whereby the US risks turning into not a democracy, a pluralistic democracy with a functioning legislature and functioning pluralistic agencies, but an elective dictatorship. That has to be avoided, right? And I believe, honestly, recognizing that my expertise is American, this form of updating of the administrative procedures and policies is something that needs to happen in all mature democracies, because all mature democracies are seeing the problem of, right, are seeing the problem of democratic retrogression, the collapsing of their traditional political parties, and political hyper polarization and dysfunction. I hope I haven't taken too much of your time, and I very, very much appreciate you sharing your time with me and honoring me by listening to this presentation. I thank you all, and I wish you all a terrific Christmas holiday season. Take care. Bye-bye.